My topic is whether the concept of no case to answer in relation to fact-find hearings has its place within family law. I think it does. I think the takeaway point is, however, that we're not allowed to call it no case to answer. And I just want to use the couple of minutes that I've got to share my thinking with you about this and to give you some tips to take away and hopefully put into practice. Many of you will know that the concept of no case to answer is familiar and well established within the criminal jurisdiction. The concept with the local infamous case known as the Manchester case. That was a case in which Sir Mark Headley gave judgment, and he concluded that the family courts do have the power to, in effect, kick proceedings into touch before the conclusion of the evidence. But he was keen to stress that the power was to be used in the most exceptional of circumstances, and we are yet to have a reported case that has passed the threshold for exceptionality. On the back of the Manchester case, you may have seen some practitioners, silks mainly, and I hope Gemma forgives me for saying that some practitioners have been trying to push and mould this further as a concept within our world. Following on from the Manchester case, and in fact, the day after that Sir Mark handed down his judgment, Lord Justice Peter Jackson in the Court of Appeal in the matter of Re HL gave judgment on the same issue, and he concluded that whilst the court does have the power, it is safely nestled within Part 12 of the Family Procedure Rules. Of course, because of those judgments coming in on the back of one another, they were like ships passing in the night. And so the court is yet to embrace whether the decision of Re HL has in effect knocked off what Sir Mark Headley said in terms of the test being one of exceptionality. Last year, I was lucky enough to be involved in a case where these issues were raised and litigated in front of Lord Justice MacDonald. And on the facts of that case, which is a reported case of a local authority at NW and others, MacDonald stayed well away from answering the question whether Sir Mark's decision has survived that of H&L. My takeaway from reading all of the current case law on this topic is that you can make an application to have a case concluded before the conclusion of all the evidence. And so what does that mean for you in practice? It means that you make an application. And like many have said on the link tonight, if you're making an application, make sure you're ready to argue it. So have a skeleton argument in support. In my view, you're likely or more likely to have a more receptive ear from a judge and make more progress if you frame it under Part 12 rather than hanging it on Sir Mark Headley's decision. And of course, if you push it through under Part 12, you'll find yourself maybe in the more familiar territory of arguing on the Oxfordshire criteria. In my view, the other benefit of going down the Part 12 route is that you can draw on the current guidance from the President in terms of his roadmap, where he makes it clear that our judges are under real pressure to manage precious court time efficiently and effectively. If you are for the local authority, in my view, be alive for these arguments coming your way and for them increasing in frequency. Show your workings out and that your workings out have been done offline as well as in the court arena using Part 12 and the Oxfordshire criteria. Show that you've applied it to your internal decision making. But also don't be frightened if, as a result of one of the respondents making this type of application, it forces you down the pathway of having to give proper and active consideration to making an application to withdraw from proceedings. My final tip for you all is that when proceedings start that involve complicated questions of fact, develop chronologies, timelines, and schedules that are key working documents. What I mean is that these are documents that you can add to and move forward with. That makes you more adaptable and agile at being ready to jump in and make that critical application, because you may not have much time. It may literally have to be made once the last witness for the authority has concluded his or her evidence. I've had a few complex cases recently where the pupils at unit and I have been crafting these key working documents, and I cannot emphasize the value that they both have in terms of developing case planning strategy and as use as a forensic tool for cross-examination. So in conclusion, my 3 points would be: 1, thorough preparation from the outset. 2, don't be frightened of making that application. What have you got to lose? Even if you're not successful, you may actually engage with the judge in a different way. You may get the judge to start thinking more in line with your end objective. And 3, have the case law to hand and know it.